Seek your Lordship indulgence in mentioning item 11. Lordship,
Part what?
though it is fixed for today, Lordship,
Yes.
but
happened?
it's a joint prayer made by both the parties, Your Lordship. There is no urgency in this case, so it may be taken up after vacation, Your Lordship.
Yes, Lalropari,
My lord, we have no
no
objection.
objection. On the submission made by the learned counsels for both the parties, list after the ensuing vacation. Yes.
For admission, item 1.
May it please your lordship. Uh, Steps have already been taken for the newly pleaded respondent number 14. Eddie Card has not yet returned. Service may be awaited.
Heard Ms.
Bila Ramnemi.
B. Ramnemi, learned counsel for the petitioner, who submits that they have taken steps upon the newly impleaded respondent number 14. However, the service of notice is still awaited. In view of the above, we may await for return of service of notice from the newly impleaded respondent number 14 list after 3 weeks.
Obliged.
Item 2.
Yes,
Your lordship, I'm appearing on behalf of my senior, Miss Valentina. Lordship, the leading counsel, Miss Valentina, is on medical leave, and if the matter may be kindly listed again after vacation.
you're appearing on behalf of?
Miss Valentina,
Where is she?
she had surgery last week.
Okay, mention is made on behalf of Miss Valentina Laldinpui, learned counsel for the petitioner, for adjournment of the matter, since the learned counsel is not able to appear due to some personal difficulty. In view of the above, list after the ensuing vacation. Yes.
Item 3.
My lord, pleadings have been completed in this
So?
matter. And
So it's listed for admission hearing today.
yes,
Are we ready?
my lord, if this may be kindly taken up after the ensuing vacation.
What happened?
I have received the affidavit in opposition filed by the state respondents. And the instant petitioner has he had some instructions to give.
You see, because today it's listed for admission
Yes.
hearing, isn't
Yes,
it?
my lord.
Okay, heard Mr. Tilal Zekima, learned counsel for the petitioner, who submits that this matter may be listed after the ensuing vacation, since he has yet to receive some instructions from the petitioner. Is it correct?
Yes, my lord.
In view of the above, list after the ensuing vacation. Yes.
Obliged.
Item 4.
May it please your lordship. My lord, as per the last court date, we were supposed to provide the registry with the updated address of
Yes.
the respondent number 3. The problem is that, my lord, we are not able to locate the address, the addressee. And, and another problem is that this particular respondent was not represented in the trial court also.
Who is the respondent number 3?
Is the
Is the
driver,
driver.
my lord.
So what is the appeal about?
The
Is it
appeal is
concerning the, yes,
Yes, it is on the quantum, my lord. We are not exactly denying our liability as such, but we are unhappy with the quantum in the manner in which it has been calculated.
then maybe we can do away with the presence of respondent number 3,
That would be fine, my lord.
because it's only concerning the quantum.
Correct.
It's
And
not
plus,
regarding the vehicle.
the owner is also, the owner that is Mizofed, they are represented anyways.
Heard Mr. Alal Fakoma. learned counsel for the appellant, who submits that though this court, in its order dated 03/09/2024, had directed that fresh steps are to be taken upon respondent number 3. However, the correct address of respondent number 3 is not known. Full stop. The learned counsel for the appellant further submits that since the instant appeal is with regards to the quantum of the award given by the learned MAC tribunal, he submits that the presence of respondent number 3 may not be necessary in the instant appeal, who was also not represented before the learned tribunal. In view of the above, this court finds that notice need not be issued to respondent number 3. Yes, can the matter be listed for hearing?
We can have it.
Yes, Lordship.
LCR received, is it required?
LCR is there, madam.
It is seen that LCR is received. Respondent number 1 is duly represented by Mr. Yes,
Yes,
Johnny.
John, Lordship, yes.
Lawsong.
And for
And
respondent number 2.
Mr. Roshan Subedi is present on behalf of respondent number 2. In view of the above, this is matter for hearing after 3 weeks.
Yes, ma'am. Deeply obliged.
Item 5. 6,
Yes.
My lord, I have taken steps upon the respondent number 6 and 7. They were the officials of La Autonomous District Council. At present, they do not have standing counsel, and service report is still awaited in respect of the said respondent 6 and 7.
Yes, heard Mr. Victor L. Ralte, learned counsel for the petitioner, who submits that steps have been taken for issuance of notice upon respondents number 6 and 7, and return of service is awaited. In view of the above, we may await for return of service of notice upon respondent number 6 and 7, list after 3 weeks. What about the
State
State.
respondents were yet to file a affidavit in opposition, my
Okay,
lord.
Mr. Samuel L. Sangte, learned additional AG for the state respondent, submits that they have yet to file their counter affidavit. After that, in view of the above, list
My lord,
after 3
another
weeks.
small prayer, if your lordship may kindly see the order dated 12/8, the last paragraph.
Yes,
I'm supposed to file the deletion order from the other writ petition, but I still need time for this also. This WPC number 90 of 2019 is filed under the association,
okay,
and I'm supposed to file this application, this order, but I still need some time for this. In the meantime, I'll be filing.
okay. Before, in view of the above, the learned counsel for the petitioner has also prayed for further time to find further time for deletion of the names of the petitioners in WPC 90/2019 in terms of this court's order dated 12/08/2024. Okay, then in view of the above, list after 3 weeks.
Thank
Obliged.
you, obliged.
for order, item 7.
Yes,
Lordship, I am appearing for item number 7 and 8. Lordship, my clients, the accused petitioners, have been in jail for 404 days, Lordship. And Lordship, a trial has been going on. Earlier, before this learned honorable court, they approached for bail, but learned judge directed to first appear before the first approach before the special
okay,
judge.
yes, that case,
Ye- yes,
so what
ye-
happened?
Your Lordship. But Lordship, it's a long incarceration. Lordship, my humble submission that Lordship may kindly admit our petition.
So did you approach the
Yeah.
trial court for bail?
Lordship, we
You
approached.
did? And where's the order rejecting your bail application?
Lordship, order is here.
At bail?
Lordship, annexure B and C. Lordship, page number 104.
Yes. So on what grounds was it rejected, your bail?
Lordship, our humble submission was that there were serious violations under section 42, subsection 2, 52A and 57, Your Lordship. But as to the kind opinion of the learned special judge declined our submission and rejected the petition. But Lordship, if we go through the charge sheet, Lordship, there are serious violations, Lordship.
Okay, read the operative part of the order.
Your Lordship. Lordship, for two accused, learned special judge clubbed and passed the same order, Lordship. Lordship, kindly see para 4,
Para 4. Okay.
Lordship. Perused, may I read, Lordship?
Yes, please go ahead.
Perused the application along with its annexures as well as the case record. The seizing officer and investigating officer have been examined and cross-examined in the court, and their deposition showed that seized contraband substances of commercial quantity were recovered and seized from the joint possession of the accused applicants, and that both applicants belong to the neighboring state of Tripura. Lordship, para 6, with respect to the claim of the counsels that the applications have been pending for more than 2 months, the court wishes to point out that both the applicants have been received and marked for registration on 7/6/2024 only and put up before the court on 11/6/2024, on which date the first order was passed. Lordship, para 6, With respect to the alleged violation of Section 42 of the Act, it is seen that the information is reduced into writing and is submitted to the superior officer, that is the officer in charge of Anti-Narcotics Squad, Excise and Narcotics, ISOL, who also countersigned it on the same. The seizing officer is an ASI duly empowered by the state government under Section 42 of the Act, and his information report is duly submitted to his superior officer within stipulated time as per Section 42 subsection 2 of the Act, and the provision of Section 41 of the Act is not attracted in the instant case. As such, the court opines that the recovery being a commercial quantity, the twin conditions of Section 37 of the Act is not satisfied by the accused applicants. Hence, the applications for bail are rejected and disposed of, Lordship. But,
So
Lordship,
that is the reasoning made by the trial court.
Lordship.
So now you have approached this court
Lordship,
the second time
Lordship,
on the grounds that Section 42 has been violated.
Lordship, if we, Lordship, my humble submission is that Lordship may kindly consider the charge sheet, Lordship. We have annexed, Lordship. And if we go through the charge sheet, Lordship, on 22nd August 2023, around 8 p.m., Lordship, information was received by the officer. And only that part, Lordship, was written, noted down. And after that, around 3 a.m., Lordship, accused persons were arrested by that officer, Lordship. But during that period, Lordship, enough time was there to take authorization from superior officer. Lordship, nothing was there in the charge sheet. We did not get, Lordship, as we get the accused copy, Lordship. And Lordship, if we go through the inventory, Lordship, Lordship, in inventory, there is no sign of any judicial officer, Lordship. In the charge sheet, inventory is annexed, Lordship, only by the investigation officer, Lordship. And Lordship,
Now, what is the case? The case is at its trial stage?
Lordship, at
The
that,
charge sheet has been filed? that
Yeah,
means-
Lordship, Lordship.
So how many witnesses have been examined?
Lordship, no, Lordship, not so many witnesses were not examined yet.
So how many witnesses?
My lord, there are 9 witnesses,
Nine
and out of
witnesses.
9 witnesses, 5 witnesses were
Five
examined.
witnesses have been examined. Okay. We'll issue notice. Let's see.
Lordship. Lordship, I humbly submit, if Lordship permits, the case may be fixed on 22nd October.
Okay. Heard Mr. Siraj Ali.
Ali, yes, Lordship.
Learned counsel for the applicant, who has filed the instant application under 483 BNSS for the release of the applicant on bail. He submits that the applicant was arrested on, when was he arrested?
Lordship, 22nd August 2023.
22/08/2023 for the alleged commission of the offence punishable under section 22 within brackets C of the NDNPS Act and excise and narcotic case number N-231 of 2023 was duly registered and charge sheeted. He submits that the applicant has been in judicial custody for the past how many days?
Sir, Lordship, 4 days, 404.
404 days. And the applicant is entitled to bail for the non-compliance of the mandatory provisions of section 42 of the NDNPS Act. Stop. Issue notice to the respondents. Ms. Vanessa Siami, learned additional PP, accepts notice on behalf of the state respondents. Requisite copy of the bail application to be duly furnished to the learned additional PP if not already done. List on, when did you pray?
Lordship, 22nd October.
22nd, 10, 2024. Yes.
So kind of, Lordship.
7 and 8, same order?
Same, Lordship.
Same order for item number 8.
Item 9.
Yes.
My lord, I was going through the notice. There is no return of notice against the respondent number 1 and 2.
What is the IE about?
It's for condonation of delay of 139 days. There is no report, no return.
And who is the opposite party?
The,
A private person? Private respondent?
Some of them are claimants, some of them are the owner of the vehicle and the driver of the vehicle. So
When
notice
did you
has,
issue notice?
on 38, I have taken steps, and the office note indicates that there is no return from respondent 1 and 2.
Heard Mr. Roshan Subedi, learned counsel for the applicant, who submits that steps were taken for issuance of notice upon respondents
All the
number,
respondents.
number
1, 2, and 3. All,
1, 2,
and 3. All of them.
1 and 3. Is it?
All of them, 1, 2, and 3.
Okay, upon respondents number 1, 2, 3. However, service of notice is not returned till date. In view of the above, we may await for return of service of notice upon respondents number 1, 2, and 3, list after 3 weeks.
3 weeks. Online.
For hearing, item 10.
My lord, before we proceed further, my lord, I'd like to point out that this is a complaint filed by the Lok Ayukta, and the Lok Ayukta has a special PP in the High Court.
Yes, who is a special PP?
JC, Mr. JC, is supposed to appear in through VC.
So if Lokayukta has a special PP, what about the PP? State, are you going to participate or you're
That's
going
what,
to?
my lord, we have
If I may,
some
Your Lordship.
problem regarding that, because in other cases, my lord, the Lok Ayukta special PP has appeared in the High Court also.
Huh.
And in the
So-
trial court, all the cases are handled by the Lok Ayukta's additional PP.
Okay, then the state PP is not supposed to play a role or what? What is the system?
That's
Then
what,
we'll have to wait for maybe both of you.
yes. I think the leading counsel should be the special PP Lok Ayukta in this case. We can also participate, but we are only the investigating agency in this case.
My lord, if I may,
Yes,
the Lok Ayukta had submitted one IA number 56 of 23. If your lordship can kindly go through that. In the last court, or in fact, by filing that application, they had prayed for impleadment as a party respondent in the present case, which was not allowed by this honorable court due to the fact that there is no provision for impleadment under the CRPC.
yes, so even if they are not impleaded,
Right.
if the case was initiated by Lokayukta, isn't it?
But it
So,
was
but
hand-
who had appeared before the trial court, special court?
Special court, the PP was there, my lord. Special PP,
Then
not
if-
the special PP assisted the additional PP.
Yes,
Only assisted.
So,
So
I
the
think-
lead was
yes.
taken by the state.
yes, I think it has to be the state because even though it was initiated by Lokayukta,
This,
okay,
they are
during
a-
the trial. in the
exactly, my
special,
lord. They are a
court.
quasi-judicial body, my lord.
Yes. So, but however, since they are absent today,
No, what I mean to say is that, your lordship, in that IA, that IA was dismissed.
the IA was dismissed because there's no provision for
Correct.
impleadment under
Correct.
CRPC. Okay, but he is or they are supposed to appear automatically for the criminal appeal, isn't it? The IA is an impleadment application. There is no provision for impleadment application under CRPC, so
Correct.
it was dismissed.
Correct.
But since in the criminal appeal, okay, where it was initiated by Lokayukta, they can always take part and assist the PP.
Correct. At the most, assist the PP.
Assist the PP.
So, in fact,
uh,
my humble prayer before this honorable court is that, your lordship, due to the hanging of this particular case, I have been overlooked for my promotion also. All my juniors have superseded me due to this pending criminal case. And my promotion is going to be subject to the outcome of this case.
we'll fix it immediately after the vacation if it's required, isn't it? You see, because now Lokayukta is taking keen interest, it appears, and they had even gone ahead to file an impleadment application, which was rejected mainly on the grounds that there is no provision under CRPC. But this denotes that they are keenly interested in this case, isn't it? So we'll
My
fix
lord,
another
let,
date for
let
the
them file a
appearance.
written argument later on if they want to buttress the submission
Let
of
them be
the
present.
PP.
Is the PP ready for hearing today?
My lord, I'm ready, but however, my lord, the Lokayukta, they have the
Let it present
special
within-
PP.
Yes.
Otherwise, let it,
They
let,
have-
let this proceeding start today, my
Lokayukta
lord.
will have a special PP.
They
Let-
have
let
the
this-
special
appear.
PP, so I
Okay.
don't think the
Then
role is
we will
only to
hear
assist.
both of them. Okay, we will hear both of them. The PP will take the lead. Okay.
In
Because
other
their
cases-
special PP, in other cases,
In
which
other cases before this honorable court also, my lord, the special PP is allowed to appear in other cases.
So we'll hear both of
Allowed to,
them.
allowed to appear, not
Yes.
necessarily
So
appear.
we will allow. And since it is clear that the Lokayukta wishes to participate in this case by filing an impleadment, by going as far as filing an impleadment application, which was dismissed
I am in
mainly
abs-
on the ground
I am in absolute
that there is
agreement.
no provision
I
under
am
the
in
CRPC.
absolute agreement with your lordship,
So
but-
we'll list it immediately after
But
the
your lordship,
hearing
the fact that
vacation.
they are
Yes.
absent today clearly shows that they are not interested in prosecuting the
How many
case.
times have they been absent?
They have been absent most of the time, my lord. Only after filing this impleadment that he has never appeared.
You see, because this is the first time that this matter has been listed for hearing. If in the next date the matter is adjourned, now we'll adjourn the matter today due to the absence of the special PP for Lokayukta. Then in the next date, if they are again absent, then we can consider that they're not
Then
interested.
at least
isn't
let
it?
that observation be made, your lordship.
This is the first time they're being absent. We will await.
My lord, he's supposed to be, to appear today.
He
has
is
informed me.
aware of the fact that the
Online,
case is
Yes,
listed
my lord,
today.
I think there's some problem with the connection maybe.
So we'll fix, okay, we'll fix it immediately. We'll give us a date when do you want it, since there's urgency in the matter.
Yes, your lordship,
Yes.
there is urgency. If we
So,
can have it on the,
let's
yes.
fix it, let's fix a date.
If
When
we
do you
can
want
have it on the 15th of October, my lord.
15th October?
That is immediately
Okay.
after the vacation.
Yes. Heard, Mr. Lalfakoma, learned counsel for the appellant, along with Ms. Linda L. Fumble, learned PP for the state respondents. The learned PP submits that since this matter was filed by the Lokayukta, the special PP for Lokayukta may be present. She further submits that the special PP for Lokayukta was to appear online. However, it appears that there is some problem in the connection. In view of the above, this court find it fit to fix this date on 15/10/2024, since the learned counsel for the appellant has expressed urgency in the matter. Yes. Accordingly, list on, so, yes.
Can we have that observation
For
that
the
if they're
appearance-
missing, your lordship, in the
for-
next court
For the
date?
appearance of the special PP for Lokayukta. Yes. What did you say just now?
If that observation can be incorporated in the
her-
order, that
So if we
he
have
should be
made it-
present in the next court date,
For
because
the
otherwise,
presence of the special PP for Lokayukta, we have made that, isn't it? Yes. Any other matter for hearing?
Ay, kesa man po, kesa, kesa ko pamating, bandal mo, kesa ko pamating.